Good afternoon, Your Honor. Omar Shah on behalf of the people, PH 6332.
Good afternoon, Your Honor. Edward Taylor, P571166, hearing on behalf of Mr. Spencer. Mr. Spencer, will you introduce yourself to the court, please?
Randy.
All right, folks, when a judge starts off by saying they were about to issue a warrant, it's safe to say things are already off to a rocky start. Mr. Spencer is walking a thin line here, if not for his attorney personally dragging him into court. We might be watching this from a jail cell. This isn't just a case of oversleeping. This is a courtroom that does not hand out second chances lightly. So buckle in. It's going to be a ride.
Okay, Mr. Spencer, you were supposed to have been here this morning. Lucky for you, your attorney was willing to go pick you up because I was issuing a warrant.
Just take a second to imagine this. Your lawyer has to leave their office, drive to your house, and escort you to court like a personal chauffeur. That's not normal. That's not even kind. That's desperation to avoid contempt of court. The judge is stunned, and rightfully so. This kind of casual disregard for procedure, it can and often does turn into a legal disaster. And by the way, if you're on a court docket, being just at home isn't a flex, it's a warning flag.
So why were you just hanging out at your house and not here at the court?
Well, I did go on the Zoom this morning, but it was difficult to do.
Okay, so I will acknowledge that I did see you in the waiting room on Zoom. We've been having issues with people impersonating names on Zoom and submitting inappropriate videos. So I will acknowledge, counsel, that I did see your client's name in there. I have no way to know if it was him. And as you can tell, I was a little hesitant to invite some people today. And
I've seen the video, Your Honor. Judge King showed me some of his.
Oh yes, Judge King gets some doozies also. Okay, so, but then sir, when you were having difficulties, did you contact the court?
Let's break it down. This was supposed to be a simple Zoom appearance. Courts offer these options for convenience, especially for quick procedural hearings like the PCC probable cause conference. But there's a catch. Zoom is a tool, not a loophole. If your tech fails, the court's patience doesn't extend to your Wi-Fi signal. The judge is laying out a clear message. If you can't show up digitally, you better show up physically. No excuses, no exceptions.
Okay, absolutely you should have. Or you should have somehow found your way here into the courthouse, right? So the court allows individuals and attorneys to handle the PCCs by Zoom because those are generally pretty quick, right? And a lot of times attorneys have multiple PCCs at one time. So courts aren't all waiting on the same attorney. This court and other courts allow individuals and attorneys to appear by Zoom for PCCs. That doesn't mean that's the only way to appear. So if there's technical issues, you need to be in person. Okay? All right. So I'm all done lecturing for the day. Counsel?
Yeah, I indicated to Mr. Spencer's statutory right for a preliminary exam in this matter. At this time, he wishes to wait.
Okay. And Mr. Spencer, you've heard everything that your attorney has indicated, correct?
Yes.
All right, and so we do understand that you do have the right to have a preliminary examination where it must be shown that a crime that's committed for probable cause exists to charge you with that crime. You also understand that by waiving your right to a preliminary examination, that your matter will be bound over to circuit court on the charges in the complaint warrant, correct?
Yes.
And has anybody promised you anything, threatened you, or coerced you in any way for you to waive your right to your preliminary examination?
No.
Now here's an important moment. Mr. Spencer is waiving his right to a preliminary examination. That's a legal hearing where the prosecution has to show there's enough evidence to justify going to trial. Waiving it means the case skips this checkpoint and goes straight to circuit court. And the judge? She's making absolutely sure he isn't being pressured or manipulated. No backroom deals, no threats, just Mr. Spencer agreeing, under oath, to move forward. A calm before the storm.
All right, and the court will note that examination having been waived, defendant found over circuit court for further proceedings. You are to appear in circuit court on October 5th at 9 a.m. on the charges of the complaint. All right. Anything else, counsel?
No, Your Honor.
All right, bond and conditions are continued. Mr. Spencer, if you were to test today, what's in your system?
Alcohol.
Alcohol. You were consuming it today, weren't you?
Yes.
Yes, okay. So, so here's what I need to know. Now that I've accepted the waiver, are you under the influence of the alcohol?
No, not more than that, no.
Not, what does that mean?
That's all.
What?
It's not much sleep, that's all.
Okay. Counsel, I'm going to have a PBT administered to your client just to make sure that your client is.
Whoa, hold up, did Mr. Spencer just admit he's been drinking today, while in court? That's a massive red flag. The judge picks up on it immediately. When someone is waiving a legal right, they need to be in a clear mental state. Alcohol analytic calls that clarity into question. The court isn't guessing either. They're ordering a PBTA preliminary breath test to confirm whether he's sober enough to understand what he's agreeing to. This isn't just formality. This is protecting the integrity of the justice process.
Not intoxicated to enter into this waiver. Okay, so let's go off the record for a moment. And then we need a PBT. Gordy, can you ask the PD if they can bring over a PBT real quick, please? Thank you.
Your Honor,
Hello, yes,
or this gentleman?
Yes.
Okay.
thank you.
What you're gonna do here is just you can just grab it and blow one long continuous breath until it stops speaking, okay? You gotta give, you don't have to push anything, just blow into that straw. All triple zeros.
Okay, thank you. Okay, I just wanted to confirm, since you did indicate you consumed alcohol this morning, I wanted to make sure that you were not still under the influence of alcohol, since we accepted your waiver. Although it's not lost on the court that you're not supposed to be using alcohol anyway, since that's one of the conditions of your bond. So it gives.
What happened again, Your Honor?
Oh, we're back on the record, right, I'm sorry. Well, sir. Okay, but why are you consuming alcohol when you're not, when you're ordered not to?
I know it's just that. I say what happened.
All right, counsel, I think that, I may amend the bond condition to include an alcohol tether for your client. I initially did not do that, given his charge, but it appears as though that's also a concern.
And here come the consequences. Based on that alcohol admission, the judge is officially changing the game. New terms are being added: random, drug and alcohol testing. She didn't originally require it, but now it's clear the court sees a pattern and it doesn't like it. Mr. Spencer might have thought this was just another procedural hearing, but he's leaving with tighter restrictions, more conditions, and a judge who's watching very closely. Oh, and if he thinks he'll get a heads up before a test, think again.
Right now he was. I'm not going to do the alcohol tether. I'm going to indicate you have to submit to random testing, sir. So bonding conditions are continued. You have to submit to random testing. So you don't know when you're going to get called for testing, so make sure that you are not consuming any alcohol or drugs. They're not prescribed. Okay, and anything else?
No, Your Honor.
Again, thank you, Mr. Taylor, for going and picking up your client. And sir, please stop over at probation. Do not leave without going to probation. You're not on probation, but they will give you the information about testing.
All right.
All right, thank you.
Thank you.
Okay, thank you.